As indicated, my name is David Levy from Keen Summit Capital Partners and Summit Investment Management. I'm based in Chicago and I'll be your moderator today. This webinar is the third part of the Financial Poise series, Ethical Issues in Real Estate-Based Bankruptcies. Slides 7 and 8 provide a summary of the episode in the series. Episode 1 covered valuing real estate assets, and episode 2 covered insider lease agreements, and this is the third and final episode in the series. Speaking of the slides, you should understand from the get-go that we will not step through the PowerPoint in order, nor will you have to listen to us read any slides. This webinar, like all Financial Poise webinars, is a conversation. Keep the PowerPoint handy, however, because that will try to indicate what slides our conversation is touching on as we proceed, so you can take notes. Our panelists today are Samantha Rubin, an attorney from Denton's in Chicago and a member of the firm's restructuring, insolvency, and bankruptcy practice. Matthew Christensen, a certified turnaround and restructuring leader from Amplio in Boise, Idaho. And he was previously a longtime attorney practicing criminal law, bankruptcy, real property, and business matters. Richard Corby is an attorney from the law offices of Richard Corby in New York City. Again, I'm David Levy from Keen Summit Capital Partners and Summit Investment Management. Keen Summit provides real estate services like brokerage, auction, lease restructuring, and more for bankruptcies and other special situations. Our sister division, Summit Investment Management, buys all kinds of distressed debt and provides bridge and bankruptcy financing. We appreciate you not spending your time or money to attend this webinar to hear infomercials about us, but you can read more about us in slides 44 through 47. This webinar is a production of Financial Poise. You can sign up to get our great free weekly newsletter by going to financialpoise.com/subscribe. If you're attending the live premiere of this webinar, you can submit questions using your web portal. If you're watching this on demand or have any questions after the webinar, you can send an email to info@financialpoise.com. Just include your name and question and the name of the webinar episode, and we will do our best to get you an answer. Special thank you to our co-producer, the National Law Review, the premier legal news website offering in-depth analysis on a wide range of business and legal topics. Okay, and with that, away we go. Today, of course, we're going to have an important conversation about ethics and specifically ethical issues in single asset real estate cases, also known as SARE or single asset cases. Our esteemed panelists will speak from different perspectives based on their professional background. Samantha Rubin from Denton's in Chicago specializes in creditors' rights and lender representation, so she will speak from that perspective. Matt Christensen, the certified turnaround and restructuring advisor from Amplio, but who was previously a longtime attorney practicing civil litigation and commercial finance, as well as bankruptcy, real property, and business matters. So for today, he will play the role of an attorney to the debtor. And lastly, Richard Corby, I like to call him Rich, from the Richard Corby Law Office in New York City, has been practicing in the areas of distressed investing in corporate transactions and restructuring, litigation, and bankruptcy, providing advice for over 12 years. So he will offer thoughts from the views of both the perspective of debtors and creditors. Let's start with a good warm-up, everyone, and begin with the key questions. What are ethics and what are legal ethics? Samantha, please start off.
Thanks, David. So ethics can be as simple as the gut feeling you get, that innate reaction that something is off. But it can also rise to, a level of legal liability, for instance, fraud or a breach of fiduciary duty. And ethics in our context here are important because they're really designed to protect the client. When you're a lawyer, protect your client's interests. And as we'll discuss in a little bit, lawyers are governed by a special set of ethical obligations as adopted by the state in which they practice. And so another issue is real estate business people can sometimes be lawyers as well, recovering lawyers like Matt here. And so sometimes the lines as to their duties in those situations can get a little blurred and a little bit more complex.
Matt, what can you add to this?
I always think of ethics as sort of the classic smell test, right? Does it smell weird? Does it feel a little funny? If it is, I think that's a good time to pause and just think about, is this something I should be doing or my company should be doing or whoever I'm advising should be doing? Maybe it still is, and there's a thicket around the ethics rules that you can navigate somehow. But I think it's just that basic ethics is like, what's the right thing to do? Does it smell too funny? If it does, make sure it's still okay.
Rich, please give us your take.
Sure, ethics. I think it's in the legal context or in just in general, is it too good to be true? Is especially with dealing with single asset real estate cases, normally it's the principal of the debtor is on the hook or is a guarantor of the loan to Samantha's client, and you have to navigate between what the client is telling you and what the reality is, and are they telling you everything, and even the embarrassing or ugly stuff, because it's going to come out in bankruptcy anyways, and along with there's the professional rules that govern all lawyers, no matter what state they're in. Each state has their own version of them, and then there's the ABA models. But also here we have the bankruptcy code and the bankruptcy rules regarding and retention and getting paid, and sort of dealing with the what can also happen in bankruptcy cases are third-party payments for debtors' counsel, which I'm sure we'll talk about later. But again, there's a whole host of rules you have to go through, and the key point is disclosure, especially in bankruptcy court, because it's all going to come out anyways. I was saying to someone, I've been an adjunct law professor at my old law school for a number of years. I always give the example of it's going to come out. Look at any look at any reality show, air quote, reality show, whether someone's in bankruptcy court, or they are getting sued by a bankruptcy trustee. It's all going to come out. You can fight it. You can hire the best law firm to file every motion to quash a subpoena, to block the information. It's all going to come out. So just be honest up front.
Well, it's a great segue to what I always like to add here in this part of the presentation as the non-attorney. Although I guess precisely Matt might identify with that to some extent now, but I recall seeing an interesting presentation from Andrew Fastow. He was a former CFO of Enron and was speaking to the Turnaround Management Association in Chicago after he was released from prison. And he was talking about ethics, of all things, and what he wanted everyone to know when he held up his prison ID card and when he held up the cover of CFO magazine, and he made the point that he got the same things issued to him, these two things, for doing the exact same set of activities. And that he came to realize when he was serving time that the individual acts that he was doing were all legal. They were approved by his bank, they were approved by the board, they were approved by his attorneys. And they congratulated him for everything he was doing, but he knew that the cumulative effect of all these actions was misleading and misleading investors, and was therefore not only very unethical, but also was a fraud. And therefore, he ultimately got convicted for that. Now, of course, the American Bar Association, the ABA, provides a framework for ethical questions that are referred to as the model rules. There's quite a few, but today we're going to highlight a couple. Rule 1.7, conflict of interest, Rule 3.1, meritorious claims or contentions, and Rule 4.3, dealing with unrepresented persons. So Matt, talk to us about how the model rules used to influence your practice when you were a practicing attorney, and should be considered.
So the ABA puts out the model rules of professional responsibility, and those rules form the basis for the rules that any bar association will then adopt itself. So if you're licensed in a state, if you're licensed in a county bar association, those groups will have their own, and they don't call them model rules anymore. It's just rules of professional conduct. And those are the ethics rules that attorneys are bound by. For the most part, they tend to track the model rules from the ABA, but there is slight differences from one jurisdiction to another. So an important point, I think, is if you're licensed in more than one jurisdiction, recognize where those differences are in the rules. But realistically, this is the set of guidelines that all attorneys have to act by is these are the rules that apply to interactions with your clients, interactions with courts, interactions with other parties, et cetera. And so there's very few things you'll do as an attorney that some model rule doesn't actually apply to.
Rich, talk to the model rules in your practice.
Sure, I think the model rules, well, you have to follow them at all times, but I think the one that keeps a lawyer up at night when you're, particularly if you're on the debt on the borrower side, it's a debtor, particularly if it's a you see these more in the closely held companies, family offices, is that the principal, you're not representing the principal of the company and the company at the same time. Sometimes those lines can get blurred because what's best for the company is not best for the principal. For instance, as I said, there could be could be a guarantee. The principal could have guaranteed the bank loan on the property. So even if the bank loan can get restructured in Chapter 11, uh, that principal is going to still be liable for the deficiency because he guaranteed the loan. And I think there it's best to advise the client that they're going to have the principal of the company, they're going to have to get their own attorney because that's going to be adverse to the bank. And even though if you're a borrower, you're still adverse to the bank, but you're trying to maybe work out a deal, work out a sale or a framework of a sale, but it's not going to include the principal's guarantee. So I think when you have the conflict, that's the conflict of interest, particularly in small companies that you have to focus on. And it happens in large companies too. I mean, you'll see in the larger Chapter 11s, there'll be an independent board or independent director. But even then, one has to make sure it's not a paper tiger. Again, it can't be using the same law firm or the same financial advisor as the company is using. For instance, if Samantha and Matt are the lawyer and the financial advisor to the company, it's best practice to not be the same advisors to the independent director or the independent board. You go out and you hire another law firm or another financial advisor or investment banker, because if you don't, you run the risk of creditors coming in and saying, and the lenders coming in and saying, well, wait a minute, you're really not, you're representing, it's one and the same. And also dealing with meritorious claims and contentions. Again, particularly in these real estate cases, because I keep going back to this, the principal of the company almost always has a guarantee on the debt. And they, the, you have to make sure, a lawyer has to make sure they're filing meritorious claims and prosecuting a meritorious bankruptcy case. It can't be just to get the audit, and I'm sure we're going to get into this later, but it can't be just to hide from his lenders. There has to be, what's the game plan in place? I mean, as one of my mentors, uh, lawyer in Chicago, would always say, any idiot can file a Chapter 11. It takes talent to get it out of Chapter 11. And here, the principal may just want to keep the bank at bay for as much as he can, but as the lawyer, you can't do that. You can't say, well, that's, there's going to be all sorts of claims brought against the debtor estate, the principal, and in some cases, the lawyer for the debtor. And also, so that's where, again, being mindful of representing the borrower, the company versus the principal. And also, I know we have in the slide dealing with unrepresented people. Again, this comes up. There could be a large creditor outside of the lender or someone else that's not represented by counsel. So you have to be very careful not to give them legal advice, because I'm sure Matt and Samantha have seen this in their practices, that when you're in a case and there's a creditor unrepresented, they'll email you constantly and call you constantly. And you have to be very careful in responding to those emails or phone calls saying you're not their lawyer. You can just give them publicly filed information about the case. So again, navigating those professional rules are something that a lawyer always has to do.
Sure. Samantha, what can you add to this?
No, I agree with everything that Richard and Matt have said. I would just add that, in SARE cases, we see a lot of filings where it's really just a two-party dispute that belongs in a different court. It's usually already been in a different court. usually foreclosure, receivership. And so when that company files bankruptcy, you'll usually see the lender try to lift the stay or even seek dismissal. And so the debtor that's filing really needs to focus on, how am I going to reorganize? What's the plan here? Because for SARE cases, they're not really allowed to linger in bankruptcy. You have a 90-day, we'll get into this a little bit, but you have 90 days to pay or propose a plan. And so when you're debtor's counsel, you need to make sure when you go into the case, you're advising your client of that. You can't really just linger in bankruptcy. You need to have a plan. And so to Rich's points, the best lawyers will tell their clients that and make sure they have a plan to get out of bankruptcy. One other thing, working at a large law firm, we sometimes will represent a lot of different parties and the bigger cases. And so when there's a lot of different parties involved, we have to be mindful of who we're representing and whether those clients might, they might not be adverse to each other right now, but maybe someday down the road in the case things change. And so when you're representing the debtor, there's certain rules, you have to be disinterested, and you have to look to the bankruptcy code to see, the bankruptcy code tries to make things straightforward and lay out rules of what's what's okay and what's not, but sometimes there is room for debate on what it means, and the conflicts can be highly factually specific, so you just have to be careful there.
Well, moving along, Samantha, I've got a pet peeve about always making sure we're defining terms as we go and not taking for granted that everyone who may be viewing the program knows all these terms. So please walk us through some key terms in this presentation. Single asset real estate case. What is a single asset real estate case? And also the term automatic stay.
Thanks, David. So yeah, SARE case is one where really the entirety of the debtor's business relates to ownership of a piece of property or a project. And that's not the technical definition in the code, but that's how I like to think about it. Generally, there's only a handful of creditors in the case, usually a loan or mortgage on the property that makes up the majority of the debtor's debt. And one thing that's important to know in SARE cases is that there are more restrictions imposed by the Bankruptcy Code. For example, as we touched upon a little bit earlier, a SARE debtor can't count on the automatic stay being in place forever or for an extended period of time. And so to define the automatic stay for us, for the non-lawyers out there, it's basically a pause button where once the debtor files bankruptcy, sort of the rest of the world pauses. It's an injunction and people can't take actions, parties can't take action that would affect the bankruptcy estate, the property of the debtor. So in a SARE case, once you file, the debtor must do what we say sometimes is plan or pay within 90 days of the case filing. So what that means is they have to file a plan of reorganization that has a reasonable possibility of being confirmed, or they need to start paying monthly payments to the secured creditor at the non-default contract rate of interest.
And overall, how would you say, Samantha, that these single asset real estate cases, how do they overall play in bankruptcy?
What I usually see is they're two-party disputes. You have the secured lender, mortgage holder, and the debtor. And usually you'll see the lender file a motion for a bad faith filing, a motion to dismiss or a motion to lift the automatic stay to continue litigation that's already been occurring outside of property, to foreclose on the property, to sell, maybe a receiver is already in place, they want to sell the property. And so the lender will want that to proceed out of bankruptcy court. And so, a secured creditor, when the SARE property is in bankruptcy, they can foreclose on the collateral within 90 days unless the debtor proposes a plan. And that can be difficult to accomplish. So if the property wasn't doing well before bankruptcy, if it's not cash flowing, it's not viable, it can be difficult for a SARE debtor to, take advantage of bankruptcy and propose a plan if it's already not doing financially well. And I would add that not every single piece of property will be considered a SARE in bankruptcy. So courts have continued to narrow the definition of what is included in SARE, from the statutory definition that's in the bankruptcy code. And we've seen exclusions, that are not counted as SARE, such as full service hotels, golf courses, senior housing facilities, businesses involving manufacturing, sales, or services. So what's considered a SARE, a single project, can be complicated, and it seems to be continuing to be narrowed by the courts.
And Rich, turning to you, let's talk about the different sides of this matter. What are some of the things that the debtor, the lender, and the judge care about in the single asset real estate cases?
Well, the judge is going to say this is now my problem. Well, first, the debtor. I'm going to give a couple sides to the coin. The cynical part of a debtor is if the debtor, if let's just assume for this example that it's a SARE debtor, it's not it doesn't have a golf course, it's not, it doesn't have a hotel or a restaurant, it's just a piece of property. And they've been in default on their first lien mortgage debt since the Johnson administration. And there has been a state court action going on for years, and we're coming right up to the foreclosure sale date, and the debtor files bankruptcy to basically stay the sale and basically have a last bit of a Hail Mary to try to work out a deal with the lender or sell the property or do something. Usually in that case, there is no game plan. And the lenders and the judge will see this. They'll say, okay, you've been fighting for years now, and now you've finally come to bankruptcy court instead of when the borrower got their first notice of default, or even when the complaint for the state court litigation was filed. That's the cynical part. Another part is where a debtor has been working with their lender and the it hasn't gone as one would hope. The debtor is really working at it, trying to find a takeout lender. I've been involved in situations working with borrowers on this aspect of when we have takeout financing in place, but it usually means taking out the senior debt at a discount. And sometimes the debtors will strategically use a Chapter 11 to cram down. I know we'll get to these terms later. Basically, cram down or force the lender to take a haircut on their loan or take it being paid over time. Sometimes we call the hope note. Or sometimes debtors will have a sale in hand, and they'll have a buyer in hand, but that buyer, I know when I represent purchasers and plug for other financial employees webinars, watch the sale, it's a 363 sales section, and that's on demand, is that those buyers will want a free and clear sale. They'll want a free and clear sale order because they'll want it blessed by a federal court judge that no other creditor can sue on old debts of the debtor, that the buyer, NewCo, is not a successor. So a debtor can come in with a 363 sale in hand because the clock is ticking, as Samantha said. It's SARE debtor has 90 days from the petition date to file a plan. So, that's the smart debtor who can get in and get out of the bankruptcy case quickly. Another example is that could, if the property and I had this case many years ago, is the property better as a rental property if it's a apartment or a hotel? Is it better as a rental property or sales? And then that frame, there really is a runway for the debtor in the bankruptcy to have the guardrails of the bankruptcy court and the judge to see that process through. Now, from a lender's perspective, it's, oh my God, now they're out the cost of their loan, then you add the cost of bankruptcy. So lenders, as Samantha said earlier, will move to dismiss the case as being filed in bad faith or seek to lift the automatic stay so that the state court proceedings can continue, but the debtor still has some time in the bankruptcy court to see if they can get their Hail Mary plan together. And in that case, the lenders will usually want adequate protection. They'll want some sort of periodic payments. They'll want reporting. There's another thing that there's usually a breakdown between management and the lender usually doesn't trust anything that's coming out of the debtors in terms of the financials. So they'll want, weekly weekly financial reports, a budget, a strict cash collateral order where everything is every dime that goes out is budgeted with maybe a small cushion for, an emergency expense. Usually these include utilities, taxes, insurance, if there's any employees, if there's a management company. It's those are the type things to look at. And then from the judge's perspective, it's they want to be fair. They don't want to kick a case out right away. There's no much, and I've been in situations where I've represented the creditor and I want the case booted as quickly, and I think I have an airtight case, and the judge will say, "No, this isn't bad faith. We'll give them a little bit of a runway." And so after you nod and begrudgingly take it, you can usually the judge will renew that will allow the creditor to renew their motion to dismiss or motion to lift the automatic stay at a later point in the case. Basically, the judge will say to the debtor, you got one more shot. If you don't have something in 30 to 60 days, the stay is getting lifted or the case is getting dismissed. And so the judge really has to conduct a factual analysis, especially if he's going to dismiss the case very early. And I know we're going to get into this later, but there really has to be an evidentiary hearing to dismiss a case because there's a lot of factual points. I mean, the law is, we'll get into what the law is, but it's really driven by the factual scenario of the case being filed. And usually a lender, when they have their motion to lift the automatic stay or dismiss, they usually have that factual predicate lined up. They'll have a declaration with probably 30 exhibits of the loan agreement, the defaults, the state court proceedings, every nasty email that the idiot principal wrote to the lenders, not thinking it'll ever be seen by anybody. Or in cases if there's been alleged to be fraud, or if the principal of the company has pocketed the lender's cash to buy I just saw an alert of a company where funds were diverted to buy a vacation house. I don't recall that being in the sources and uses in a mortgage loan for a business property. But again, that factual predicate will be there, but the lenders, and it's the debtor, and really up to the debtor's attorney that bag of hurts is going to come there, and the debtor's attorney has to be able to respond to each of those. Sometimes there's no response. Sometimes it is what it is. But again, that's the factual scenario for the judge to consider when he's going to dismiss or lift the automatic stay or convert the case to a Chapter 7 or appoint a Chapter 11 trustee.
Great stuff. Well, let's put this all into practice now with some ethical situation case studies. The first one is starting here on slide 19. Is coming from, it's an 11th hour bankruptcy filing on the eve of a foreclosure sale. And the matter was Orchard Hills Baptist Church in the Northern District of Georgia. Orchard Hills Baptist Church, we'll just call them the church, operated a single Baptist church in Noonan, Georgia. In 2007, the church borrowed $3.8 million from Branch Banking and Trust, we'll call them BB&T, on a 3-year term to construct a new building for its congregation. BB&T secured the loan with a mortgage on the property and in other minor assets of the church, in addition to a personal guarantee from a well-known real estate developer associated with the church. Over the years, the church struggled financially. The loan was modified several times and the balance reduced to about $2.6 million. In 2018, after 21 months of forbearance, BB&T sold the note to Summit Bridge National Investments. In 2019, SBN entered into a forbearance agreement with the church requiring monthly payments of $100,000. However, the church missed the first payment and SBN filed for foreclosure. On the day the foreclosure was scheduled to occur, the church filed for bankruptcy. SBN, along with other motions, moved for dismissal of the case for cause. In the 11th Circuit, a case can be dismissed for cause if the debtor files in bad faith, which requires a finding of bad faith by the debtor with an intent to abuse the judicial process after weighing the totality of the circumstances. The court ruled that while many factors favored SBN, the church did not file the case in bad faith. Weighing towards a ruling of bad faith were findings that 1, the matter is essentially a two-party dispute between the church and SBN, its foreclosing lender. 2, the church's primary asset in the property, that is the subject of the foreclosure. 3, the church has no other secured creditors and few unsecured creditors, which hold limited debts. And 4, the church filed bankruptcy on the day of the scheduled foreclosure sale. Weighing more strongly against of ruling in bad faith in the opinion of the court were findings that one, the filing was the church's first bankruptcy filing. Two, SBN made no allegation of improper conduct by the church prior to the filing. And three, the creation by the church of the automatic stay by virtue of the bankruptcy filing was not sufficient in its own to indicate bad faith filing. Interestingly, while the court declined to dismiss the case, the court did grant SBN relief from the automatic stay based on its finding that the church owed more to SBN than the value of the property. So, first off, Rich, please define what a bad faith action means here.
Well, bad faith action, it's not defined in the Bankruptcy Code, and it's not defined anywhere. It's been developed and not defined statutorily, but it's more of a totality of the circumstances test, which I know sounds like a complete lawyer answer, like, well, it could be this, it could be that, but it gets to the point we talked about. Want to bring it back to the beginning of our webinar. A layman's definition of ethics versus what the professional rules say. Here, there's on its face, there's plenty of examples of bad faith. It's they haven't paid they haven't paid the note in 21 months. There's no employees. There's no they filed the bankruptcy on the eve of the foreclosure sale. The primary asset was the property. However, to address what I said earlier about how the judges want to be fair, interestingly, the judge granted the lender automatic stay to continue their foreclosure proceeding, but kept the bankruptcy case going, basically giving everybody their chance to, to try to get to the end game that they wanted. The debtor still is the bankruptcy case. If they could figure out a plan, pay off SBN, or find a buyer, or put up more money, or do a takeout loan of SBN, or on top of the note they bought, and SBN can continue their foreclosure proceedings in state court. Although I didn't look back at the specific order granting the stay relief motion. I'm assuming it said something. The lender is permitted to continue foreclosure proceedings up until collection of judgment, and then at that point they have to return to the bankruptcy court to seek a further modification of the automatic stay to collect on the judgment. And here as a lender or as a creditor, I'd be completely frustrated. But getting the stay relief entered was the splitting of the baby. As far as I know we'll get to the good faith aspects here, but the fact that it's the first filing, which that may sound silly, but in a lot of these SARE cases, there'll be 1, 2, 3, 4 previous filings. So, and that's usually, if there's multiple filings, that'll get dismissed very early. And here, I think the fact that it was the first filing, and the judge lifted the automatic stay, is basically giving the debtor one last shot to get their house in order, so to speak.
So, Rich, overall, as things stand with this first variation of the fact pattern, does this strike you as being a shrewd play by this church, or is this a little shady?
It's like I said, it's probably shady for the principal because he's got a guarantee on the debt, and that's probably what drove the filing. But it's not illegal. It's not an ethical rules violation. And now, I mean, this is a very common case, and I think maybe shady by the principal of the company. I don't think the lawyer did anything incorrectly by filing the case on behalf of the company or the borrower.
Thanks, Rich. Samantha, what do you think of this case study?
Yeah, I agree. I think that this scenario raises maybe ethical tensions, but not necessarily clear violations. And I think there's also some special considerations here, given we have a religious nonprofit. I've, represented a couple of nonprofits, on a pro bono engagement. And one thing we always talk to them is about their fiduciary duties in times of distress, because they owe duties not just to the charitable mission, but to their creditors. And so there can sometimes be, conflicting courses of action when you have those two in play. And so here it doesn't seem to me like there's been any fraud or misconduct, the church needed a loan to continue its operations, and it seems like they were just trying to preserve their mission and not just evade debt. They just couldn't make the payment. But there's some ethical considerations here, like, was it responsible for them to take on such a large debt? Is the bankruptcy filing, consistent with the stewardship of their donor funds? Was there a discussion of that before they filed bankruptcy? But on the other hand, maybe the bankruptcy is viewed as, they're trying to preserve their congregation and preserve their mission, which would support ethical justification for this filing. So, the lawyers here would just they would have a duty to explain to their client, those issues here so they can make an informed decision before they file bankruptcy.
Thanks, Samantha. Matt, anything to add to this first turn on the case study?
I think on the ethics side of it, I think, like Samantha said, it kind of comes close to that line. I think you could temper that somewhat if you're the debtor's attorney by sort of informing the client, like, hey, look, there's some facts here that look like a bad faith case, right? It's a two-party dispute. Essentially, there's no real other creditors. Your really only asset is this building. So there's a good chance there's going to be a motion to dismiss filed and we might lose. And so I think some of that disclosure that you give to your clients helps temper the ethics obligation. Not doesn't temper the obligation, but are good facts for informing the client that, look, this may be only buying you a couple of months until the dismissal happens. I had at least one case like that we filed that, look, there's a good chance a motion's going to be filed. There's a good chance 3 months from now you're out of bankruptcy, not because you got a plan confirmed, but because they won that motion to dismiss. And that's exactly what happened. So I think some of that early disclosure to your client helps sort of temper the state bar's view on whether there was an ethical problem.
And Matt, how did things change if we change the fact pattern and we establish that the church actually had a bankruptcy filing? The loan was originated in 2007. They filed bankruptcy, for example, in 2010. This would be the second. How does this change your view of the case study?
Yeah, so this would be the second bankruptcy 10 years after the first one. So in my view, I think that changes things. Rich talked about this is sort of the last Hail Mary pass by the bankruptcy judge is going to allow on. I think if you're in a 2020 case, 10 years after the first bankruptcy was filed on realistically what looks like a construction loan for 3 years, you had your chance to reorganize it 10 years ago. We gave you that chance. You got a plan confirmed. Now you're not performing under that plan. It's still essentially a single asset real estate, two creditor dispute. I think, if the judge is sort of weighing those factors on whether it's a bad faith filing, that's enough to push it the other direction and say, yeah, this is a bad faith filing. Go home. You're done.
Samantha, what do you think of this change in fact?
Well, to play devil's advocate a little bit and maybe to take the debtor side here, if I was debtor's counsel, I would want to, in that first, the first day declaration, maybe paint this as, we filed for a different reason in 2010. Maybe the financial crisis had something to do with why they were filing. People just don't have a lot of money to donate to the church, or however they, receive the majority of their income. So I would try to paint this as that was a totally different scenario. We're having a different issue now. These bankruptcies are totally separate, and try to lean into that factual analysis to show, we're not filing in bad faith. We had different issues then, we have different issues now.
Rich, anything to add to this second variation in the fact pattern?
Well, again, the length of time, that was 10 years ago. I mean, there are many companies that file, just non-SARE debtors that file, every 10 years. I think the one thing the debtor would argue that was 10 years ago. I mean, if it was 2 years ago, 1 year ago, that's a different story. But I think 10 years, I don't think it alters the fact pattern to make it a bad faith filing. I think because just the extension of time.
Let's do one other change in fact pattern here. Samantha, what if this church had 50 employees versus what if it only had 5?
Yeah, so like we talked about, bad faith analysis is factual. And so the court would analyze this factor, them having more employees or less employees is just one of many. But I think that having less employees would show, they have less operations, but more employees would show ongoing business that, it requires substantial day-to-day services and employment, shows, not merely, it's not merely an operation of a property, which would mean it's less likely to be a SARE. For example, what if the church runs a preschool on site? So, they need to figure out how they can show that they're actually a SARE debtor. Um, and so these factors sort of flip back and forth between maybe they're not a SARE, maybe they are, if they have more employees or less employees.
Rich, how does this change strike you?
Well, if they're 50 or 5 employees, one thing the judge will look at is, he doesn't want people to miss a paycheck. What if this is, again, going back to the facts, it's a nonprofit, it's a church. I mean, is there, this is in Georgia. Is there a community where this will have a ripple effect if people were put out of work? And again, it goes into the fact that whether this would be a single asset real estate, what is like, as Samantha said, is there a preschool? Is there something else, at this church? So I think that actually helps the debtor that there's that there's employees, whether it's 5 or 50. So I don't think that actually leans towards a good faith filing.
Matt, anything to add here with this change in employee count?
The only thing I think it drives is potentially whether early is a SARE case. If it's a single Baptist church in Georgia that has 50 employees, really looks suspicious to me that that's the only asset that church has. Whether it's a preschool, whether it's a farm in the countryside that it operates to whatever. I just think that number of employees tells me there's something more than just a single church building that they own.
Well, I just asked the question, Matt. What on that thread, would debtors be more inclined to game the system with a single asset real estate case filing versus not seeking that classification?
Uh, I don't think so. I think the limitations and the restrictions on a single asset real estate case, just the fact that you got to push a case through, the confirmation requirements are a little bit different. The ability for creditors to get relief from the stay, I think, is a little easier in a SARE case. And so if the debtor can somehow pull it out of the world of single asset real estate, my inclination is that's what they do. And I've seen cases where, 2 months before the bankruptcy filing, it was a single asset real estate case. All of a sudden, there's a couple extra assets transferred into this subsidiary and maybe some additional debt assigned to that subsidiary, and that takes it out of the single asset realm just because there's a little more freedom and time given to other cases.
Got it. Rich, let's spend some time with one of the model rules. How would you see Rule 3.1, meritorious claims and contentions, applying to this case?
Well, for meritorious claims, you have to look at, again, do you have a game plan to get out of the case? If it's we'll just stick with it's a church building, you have, a lender that it's been 21 months since you've paid anything, uh, you know, you have to provide a game plan to the court on this is what we're going to do. We're going to move to sell the property within like 30 to 60 days. We'll hire Matt as a broker or a financial advisor to conduct the sale process. We'll give not consent rights, but we'll have oversight from the lender and the court that this property of the sale of the property is on the up and up. That would be, a meritorious claim. What I wouldn't do is run into court with scorched earth litigation against the lender, because that's not going to go anywhere. Because one, your cash collateral is the lender's collateral, and they're not going to consent to them to have their own money used against them to sue them. The judge will grant cash collateral use over their objection to like operate the business. And if there are, as we'll use to Matt's variation of the hypothetical, if there were, 50 employees and all of a sudden there were two different affiliates created a few months before the bankruptcy, the debtor has an obligation to say, yeah, we're going to look at those fraudulent transfers or potential fraudulent transfers and preferential actions to see if we can unwind those. And the debtor, the principal of the debtor may not like that because it's probably something he did to avoid it to get around his guarantee or to give him more lifeline on his guarantee. But that's something that a debtor could say to the court, like, hey, we're going to investigate this. If you don't if the lender doesn't trust us to do it, which they probably won't, we can have an independent fiduciary appointed, an examiner, do an analysis of the claims. So again, when you're looking at meritorious claims, you actually, and it can't be frivolous. You just can't put a petition on the bankruptcy docket. You have to lay out in the first day declaration what the debtor is, how we got here, where we are, how we got here, and what's the game plan to get out. I think if you go into court with a game plan, not saying it has to absolutely work, but that's a meritorious defense. If at the end of the day the stay gets lifted or the case gets dismissed and the lender gets the property, that's fine. But if you've had a game plan with the court and you've presented it to everybody, then that's pursuing meritorious claims. Non-meritorious claims is scorched earth litigation. You think the lender acted in, unless you actually have the evidence. For instance, saying that the debt of the lender is invalid, they acquired the note, the paperwork is void, they don't have standing. There's what I've seen before in other cases is Scrivener's errors in the credit agreement, and where one argued that, oh, the lender doesn't have standing in this case. And if you look at the loan agreement, it actually says that. However, but if you looked at the loan agreement in totality, it was a Scrivener's error, and it looked like it was left over from a prior credit agreement that wasn't completely cleaned up before the sale was closed. The note sale was closed. Again, things like that the lender doesn't have standing, that they're not a real lender, that the interest rates are against public policy. Again, that type of litigation, unless you actually have evidence and law backing that up to have that fight right away, a lawyer shouldn't file that and should say no to the principal of the company's request to file all that litigation, because you're not there to tell them what they want to hear. You tell them what's going to happen or give them the best, and it may not be what they want to hear. Again, that's the and again, if you want to do scorched earth litigation, and you really think there are meritorious claims, I think the debtor would have to make sure they have some sort of financing set up to prosecute that. And also, how are they going to get it done within the 90-day time frame if they're a single asset real estate case? Because that takes time. If you file a complaint, you have 30 days to answer or move to dismiss. Then that takes time. Then if the dismissal motion is denied, you have discovery. Again, the clock is, you're not only facing the lender when you file a single asset real estate, you're also facing the clock. I mean, we're in March Madness season. What happens at the last 2 minutes of the game? It feels like it's going to go on for an hour because if you're down several points, you got to foul them because you got to get the ball back, and you got to stop the clock. Here, you can't do that. I mean, maybe in some cases a judge will extend the 90-day time frame, but it's rare and it's not for as long as the debtor would want. So having a game plan, if you want to do both litigation and sale, that's a good game plan. That's meritorious. But if you just want to fight with the lender that you've already been fighting with in state court, it's not going to go anywhere, and the judge may shut it down.
Yeah, to Richard's point, I actually had that happen in a case recently where the debtor had argued that they did not actually sign the loan agreement, and so the judge actually allowed, lifted the stay so we could go litigate that in state court whether they signed the loan agreement, because that would determine so many issues in the bankruptcy case, whether the loan was valid, et cetera. So just wanted to note that.
Yeah. Well, let's get into another case study. This one on slide 24. This is another 11th hour filing, and this is in re Fairfield TIC LLC. Fairfield TIC LLC, we'll just call them Fairfield, was a single purpose entity whose sole asset was a 66.2% tenant in common interest in a shopping mall in Virginia Beach, Virginia. Three other entities owned the balance of the interest, and all four entered into a tenancy in common agreement governing control of the property. The mall owners, as co-borrowers, entered into a $30 million loan with a 10-year term secured by the mall. 10 years later, having struggled to find an exit strategy, the mall owners found themselves $3 million underwater with a quickly approaching maturity date. A year after the loan was past due, after negotiating a deed in lieu of foreclosure from one of the mall owners, U.S. Bank National Association, as trustee for the fund that now owned the mortgage, we'll just call them U.S. Bank, entered into a foreclosure proceeding against the mall. 6 days before the foreclosure sale, Fairfield filed for bankruptcy. In response, U.S. Bank moved for dismissal of the bankruptcy case for cause. In the Fourth Circuit, a case can be dismissed for cause if the debtor files in bad faith, which requires finding of objective futility of the proceedings and subjective bad faith of the debtor after weighing the totality of the circumstances. Straight out of Rich's lips here. The court ruled that Fairfield acted in objective bad faith because the case was objectively futile, finding that one, Fairfield's only assets was his real property interest in the mall, which was fully encumbered by U.S. Bank's mortgage. Two, Fairfield was a passive investor because its only source of income was its share of the net cash flow generated by the mall. Three, Fairfield was not a going concern because it did not meaningfully participate in the management of the mall. A management company was hired by the mall owners. And four, could not access the cash flow management of the entire mall to effect a reorganization. And four, any plan of reorganization would require consent and participation of the other mall owners, but Fairfield did not join the other parties in the case as debtors to show any likelihood that they would cooperate. The court then ruled that Fairfield acted in subjective bad faith because one, Fairfield held only one asset and no other ongoing businesses, income, or employees to protect. Two, the case resembled a two-party dispute between Fairfield and U.S. Bank because the few other creditors with potential claims were unsecured in amounts far less than the amount owed to U.S. Bank. Three, Fairfield filed for bankruptcy less than a week before the scheduled foreclosure sale, and after it had already lost motions to dismiss the foreclosure and appointment of receiver in state court. And four, Fairfield filed without the joinder or consent of the other mall owners, knowing that their cooperation was necessary to effect a reorganization plan. Accordingly, the case was dismissed. Okay, Matt, what are the ethical issues in play here?
I think you go back to that meritorious claims ethics rule. The Fairfield group is only essentially a 2/3 owner of the property. There's three other owners. And so whoever the attorney is representing Fairfield, who's the debtor in the case, what communication have they had with those other owners? What knowledge did they have about the other owners' positions? At least one of those owners has already negotiated a deed in lieu agreement with the bank. So you have to know that owner probably doesn't support the bankruptcy filing. And so there's communication with other party issues and some of the ethics rules that may govern that sort of communication. The fact that it was filed just a week before the foreclosure sale, like that to me is not as big a factor. I mean, that happens in nearly every single asset real estate case, and so it shouldn't be a deciding factor. What's interesting to me is that it was filed after a receiver was appointed over the property. And so that becomes an interesting issue in the receiver order. Is there a term in that order that gives the receiver the exclusive authority to file a bankruptcy petition regarding the property? If so, did that attorney for Fairfield know about that order, know about that term, and just not care and filed the bankruptcy case anyway, hoping that no one would bring up that issue? That didn't really play a role in the case, I don't think, but it's an interesting fact for me and just the knowledge that attorney had about what he was doing.
Thanks, Matt. Samantha, what's your take here?
Yeah, just to add what Matt said, I think we have to look at the true purpose of why Fairfield filed bankruptcy, and I think the court probably got it right here in that they didn't really have a legitimate reorganizational purpose here. Unlike a true operating business, they didn't have any employees, they don't have any independent operations. There's no, from what I could tell, no, realistic path or plan for reorganization. Cash flow is not great. So I'm not exactly sure what they plan to do in bankruptcy here. I would also add that there might be some privilege and confidentiality issues in terms of who the lawyer is representing for Fairfield. Now that Fairfield has filed bankruptcy, the interests from, they're the 1/3 owner, the other 2/3 of the owners, their interests have now diverged. So if I'm their lawyer, I would want to make sure um, the other owners have their own attorneys, and if they do, to communicate with them, not the other owners directly. And another issue is, if I'm the attorney for Fairfield, advising them whether or not to file, we would really need to look at the operational documents and see, do we need the other mall owners' consent? Is their cooperation necessary? Are we exceeding authority by filing this bankruptcy, which it seems like they might have been. So it might not be a meritorious filing. They don't have all of the consent of all the owners if that's not needed.
Thanks, Samantha. Rich, what can you add here?
Again, just going back, looking at the corporate org documents, um, what did they say governing the authority to file bankruptcy? And same thing with the receiver order. Did that order grant the receiver the sole ability to file the bankruptcy? Now, getting to meritorious claims, if the debtor's counsel knows about all of these things, but still has case law that says, oh, that receiver order can be null and void, that the LLC agreements are with those provisions are void against public policy because they bar a constitutional right to file bankruptcy, then yes, the lawyer for Fairfield could file this bankruptcy. If there's cases in the jurisdiction that he wants to file that go the other way, then this is a waste of time to file the bankruptcy, and the lawyer maybe run the risk of sanctions or having his pre-petition retainer disgorged, or may not even having his retention approved at all if the case is dismissed beforehand. The Again, these are a good lawyer will have to do the venue shopping, which venue is good for this type of case. Obviously, it doesn't look like it here in the Fourth Circuit, but is there a way to shoehorn it into another jurisdiction? Again, that's his own ethical issues, and you have to have a solid basis for filing somewhere else that's more favorable to you. Again, I think this one you have, and the key point here, no matter what the org documents say, who's authorized to file the bankruptcy, nothing's going to take away that you're going to need the two other owners to confirm a plan or a sale over the objection of the lender. And what can happen there, if I were the lender's counsel, is I'd use the non-debtors to co-opt against the debtor and sort of divide and conquer. So again, again, it goes back to what I said before. One of my mentors said, any idiot can file it. You got to have a game plan to get out. And obviously there was no game plan to get out here.
Sure. Rich, I'm curious though, if we change the fact pattern, how did things change in your view if the debtor was not in bankruptcy and they actually were getting an income stream? They were getting the 60%, 66%, 2/3 of the proceeds received from the shopping mall.
Well, then you could provide the lender with adequate protection in response to their lift stay motion. You could make periodic payments because if they're getting 66% of the revenue, you can, depending on, again, that's an evidentiary issue whether the lender has enough of an equity cushion because it's only 66%. But the debtor would make the argument, if that's an income stream, then the debtor is worth more alive than dead. There's very few cases that say that. I know I've cited them when I've represented debtors in this situation, and when I'm on the lender side or the ad hoc group side, I'll cite the opposite. Oh, you have to have more. But if there's a cash flow, I mean, there's a definite business, and it gets into, is this a single asset real estate? We said it's a mall. Can we use the food court as an example to make sure it's not a single asset real estate, or if there's an Orange Julius, something to that effect.
Don't forget to borrow. We're starting to run short on time, but to wrap things up here, I'm curious, Samantha, what if the other tenants in common had joined this bankruptcy? How does that change the calculus?
I think that would lean more in favor of, this being a better, way to file bankruptcy when you have the consent of the other ticks here. They could, choose to sell the property altogether, band together and reorganize, but I think they would still be having a fight with their lender. So it might not completely solve the problem, but it would maybe help them stay in bankruptcy for a little bit longer and they could at least make decisions together.
Got it. And let's touch on one other topic here today on slide 28 at the bottom there. Matt, talk to us how model rule 4.3, dealing with unrepresented person, might come into play in this case study.
So that rule, I guess in short sentences, means you have to make sure the unrepresented person knows that you're not representing them. And if it appears that they have the belief that you are representing them somehow, you have to clarify that belief and help them understand that, no, I represent this other party. So in this scenario, if you got the 4 owners, your client is Fairfield, you got to make sure those 3 other owners understand, look, I'm here to protect Fairfield's interests. There might be some overlap between Fairfield's interests and your interest as other owners, but you need to get your own counsel and participate and do your own thing, because it leads to issues when that party thinks that you're representing them as an attorney and you're not, because the interests aren't always the same. They diverge in multiple places.
Well, thank you, everyone. This has been a great program with a lot of great content and insights. And there are some other case studies that the audience can review in the deck. And of course, all the model rules. And we are out of time today. So I want to thank our panelists, Samantha Rubin from Denton, Richard Corby from the law offices of Richard Corby in New York City, and Matt Christensen from Amplio in Boise, Idaho. And this concludes our webinar. You saw we spent a lot of time talking about the model rules, so we encourage everyone to review the full text on slides 38 through 41. Thank you for joining for another entertaining yet educational production of Financial Poise. Look for Financial Poise webinars wherever better continuing education webinars are sold. Thanks, everyone. Take care.
Thank you.
Thanks, David.
David.